All right, good morning, everyone. It's 9 o'clock. Welcome to JLCAR. I'd like to thank all the legislative members of the committee for their work on overturning the veto of House Bill 1622, which has happened, and therefore it is now law, and we don't have to worry about those details again. All right, so the alternatives. Senator Gray, you can sit in for Senator Lang, and Representative Grassi can sit in for Representative Schmidt. Representative Land has said she's on her way, so Representative Hacken Phillips, you can sit in for Senator Whitley. Okay. The minutes of the previous meeting. Is there a motion?
So moved.
All right, moved by Senator Ward and seconded by Representative Groda. Any corrections, additions, or deletions? All right, seeing none, those in favor?
Aye.
Those opposed? All right, and the consent agenda. Does anyone have something to remove from the consent agenda? Seeing none, is there a motion? Move to approve by Senator Chandley.
Second.
Seconded by Representative Lynn, I think was first. Any comments, discussion? Those in favor?
Aye.
Opposed? All right, thank you very much. All right, Representative Schmidt has arrived. So, Senator Innes? Okay, yes. Ah, well, in that case, we will have a crowd. All right. All right. Okay, on the regular agenda, bingo.
So the first item is from the Lottery Commission. The commission did submit a conditional approval, which addressed most of the comments, but there were still some remaining, as there was 14 forms with this 62-page rule, so catching everything was a little difficult. But I have been in contact with Valerie King to go over the discrepancies between the form and the rule text that were missed. There were a couple editorial fixes and then one editorial unclear on page 10 of the conditional approval request due to some missing language in the rule text from the form certification. And based on our conversations, it's my understanding that the commission's going to ask for an oral conditional approval to address those items. And I can go over each one individually, or I can go right to the last issue with this particular rule.
I think we can trust the two of you to sort through the form issues as long as there's an agreement.
Okay.
Are there any other issues?
The only other remaining issue is there's a note to JLCAR and a legislative intent comment on the first page of the conditional approval, which was carried over from the final proposal. In the commission's notice that was filed with the initial proposal, it indicated that these rules are to address statutory amendments, but these statutory amendments were made back in 2021. And then additionally, there were some further amendments that were made in 2023. So there is a question about why there was a delay in implementing the 2021 and 2023 amendments. And this kind of also ties into a note to the committee on page 13 of the final proposal, where there was a statutory amendment in 2016 to the amount that private campgrounds and hotels could charge for special bingo games from $2 to $5, but it wasn't until this particular proposal that the commission updated that amount. So it seems like there's been some delays in updating the rules to reflect statutory changes.
Good morning. Yes.
Sorry.
Good morning. My name is Valerie King. I'm the Director of the Investigations and Compliance Division over at New Hampshire Lottery. That is the unit that oversees charitable gaming. Delays in implementing the legislative changes can be laid solely on me. I am in addition to my duties as the Director of the division, I also am the sole rule writer for the agency. And in the past few years, you may be aware that the gaming rules have, we've had a lot of changes to our agency with regards to legislation. We've had sports betting in 2019. We had historic horse racing added in 2021, which we promulgated rules as quickly as we could for those. But since 2021, we've had 23 new law changes, and the most recent in 2024, there were 8. So we've had a lot going on, and so although the rules have not changed, we do make sure that our licensees are aware of the statutory changes. We have newsletters, we send out email blasts to make sure that they are aware of those changes, and we do not make them comply with rules that do not, because laws supersede the rules. So we make sure they're aware of any of those changes. We've also been doing a lot of changes internally to change our processes. This, as Attorney Ricard mentioned, we have a lot of forms. We've been revising a lot of those forms and our processes to make it easier for primarily our charities to apply. For example, I recently there were some legislative changes to make sure that the definition of a charitable organization is the same across all game types. This would allow us to change our process to give charities would be apply to be eligible for all game types, and once found eligible, they can just request game dates. So we are trying to make a lot of changes, and that has slowed down our ability to keep up with legislative changes to and reflected in the rules.
Thank you. Any questions? Okay. Does someone have a motion?
Move to approve. Second.
All right, moved by Senator Lang.
Could we
second-
just make sure, though, that when we move to approve, that we have their agreement that they're going to, as part of the motion,
Yes,
that we have their agreement to work on the forms and to come to an agreement?
yes, absolutely. That is what you meant, correct?
That's what I mean.
Okay. Yes, seconded by Representative Lynn.
I'm wondering if we need to redo the seating of alternates for regular members,
Did you seat somebody for me?
Yes, I did.
because Senator Lang is now in, and
Someone else can make the motion.
Well, you're here, you're a member.
Okay.
Yes, I believe it was Representative Grassi was sitting for Senator Lang.
I-
Actually, it's Senator Gray who's sitting for Senator Lang. Representative Grassi was sitting for Representative Schmidt, but is now sitting for Senator
For himself,
Innes.
I see. So we have 5 House members who are here, 3 senators, and alternates for Senator Whitley and Senator Innes, correct?
Correct.
Okay, and then we have 3, yes, Senator?
Madam Chair?
Yes.
Since one of the House members is sitting in for a senator, I think that maybe we should revise that.
Agreed.
Okay. Senator Gray, you should sit in for Senator Ennis then. And Representative Grassi is in for Senator Whitley, correct? Okay. What? He was sitting for Senator Lang, who has arrived. Okay. So Representative Hacken-Phillips is still sitting in for Representative Whitley. Senator Gray is sitting in for Senator Innes, and Representative Grassi is available as needed. Is that correct? Everyone clear? Okay. Sorry about the confusion. I wasn't aware of who all was going to be here. All right, so Senator Lang has made a motion to approve with the understanding that the discrepancies between the forms and the rules will be negotiated with the staff. seconded by Representative Lamb. Is there any discussion? Those in favor?
Aye.
Opposed? All right, thank you very much and good luck.
Thank you very much. And I'd just like to add that Attorney Ricard has been very helpful in this process, and I believe that it's a better product in the end, thanks to her. Thank you.
Thank you. All right.
The next-
Just as a matter of formality, so Cecile, when Ms. King nods her head, are you getting that down that she's effectively voting yes? Are you getting that down? Okay.
Thank you, Representative Schmidt. Department of Energy?
So this is final proposal 2024-92 Energy 300 rules. This one is a very unique situation in that there were some substantive comments on the final proposal. The agency did submit a conditional approval which addressed all the substantive comments, but then subsequently submitted an amended conditional approval with additional changes after talking to one of the stakeholders, one of the utilities. And those changes resulted in more substantive comments from me. And so the department has today brought, which I placed on each of your seats, a revised amended conditional approval, which they will be requesting orally today, showing the changes to address my comments and then also some additional housekeeping changes. I did talk with Attorney Bailenson before the meeting and we went over these changes. They do address my comments. So on the amended conditional approval, so I have nothing further to add.
Yes, Senator?
Just to make sure we got all that right. We had a final proposal with comments. They gave a conditional approval that was okay originally. Then they made some further changes to their conditional approval, which caused more comments. They've corrected the comments with the written version after your conversation. They have addressed the amended conditional approval issues, and now we have a new version in front of us that you're okay with.
That's correct.
Thank you.
All right.
Good morning, Madam Chair and members of the committee. My name is Marie-Helene Bailenson, and I'm an attorney with the Department of Energy. I would also say thank you to Attorney Ricard for working very hard in all these different changes, which we take seriously. Stakeholders have submit comment during the public comment period and after, and we look at them closely. As background, on October 10th, we filed our amended request for conditional approval addressing all of the prior comments and edits. However, very closely after we submitted our amended request for conditional approval, we received an additional request for further language clarification from Eversource, whose attorney is in the audience here today, and I won't volunteer him for questions, but he is here. This prompted us to further amend several sections and then submit again to OLS. The impacted sections, which are in the packets before you and the form, are EN 30606F, EN 30606H1 and 2, and Form E5E. As Attorney Ricard said, one of those further revisions caused substantive comments from Attorney Ricard, and also upon further review of those sections in Form E5E, Attorney Ricard found inconsistencies between the Form E5E and sections EN 30606 and EN 30806, sorry. We believe that we have addressed the OLS's concerns, and we can explain how. Relative to the substantive comment, if you look at your packet at EN 30606F, which is the requirement for utilities to notify the department within 2 hours after becoming aware of an accident, There, Eversource requested that the accident result in a substantial degradation of operations and safety. If you take a look at F2. The word substantial was cited as overbroad and vague by OLS. We reworded the word substantial to state degradation of operations of safety that affects 500 customers or more with an expected duration in excess of 12 hours. That was satisfactory to the department and Eversource, and I believe Attorney Ricard as well. I can also discuss a little bit about the forms. Upon review of that section and the reporting requirements at EN 30606 H1 and 2, if you look closely at pages 17 and 18, Attorney Ricard noted that the Form E5E, which is also in the packet, had some discrepancies with the rules language. In H1, we have made the form and rule consistent such that utilities must file an accident report, the Form E5E, within 5 business days of notification of an accident. And in H2, we've made the form consistent with the detailed follow-up report being made automatically within 15 days of the accident. There were similar concerns at EN 30806 regarding discrepancies in reporting timelines with the E5E accident reporting form, and those have been addressed. Finally, Eversource requested language changes at EN 30606J, that's page 18, which we have included. This was to make it consistent with the provision at EN 30806B, primarily that if a death occurs as a result of a reported accident and is known to the utility, then the utility is required to report this fact in an additional report. Finally, we would also like to note for the committee that the department has begun rulemaking by filing EN 20105 rule. The department filed for fiscal impact statement and initial proposal with the LBA relative to this rule on 10/16/24 yesterday. Our understanding and expectation is that we'd be at the January JLCAR, and that the PUC procedural rules aim to be at the January 25 JLCAR meeting as well. The new department rule, EN 20105, will hopefully be approved at the same time as the PUC rule, whether that's January 25 or an earlier date, if the rulemaking proceeds even more speedily and we happen to be at December JLCAR. And this will eliminate the concern about a lapse in the department's authority to waive rules. A comment was made in this rule set where EN 20105 is referenced twice. We updated for JLCAR that we would be in the rulemaking process relative to EN 20105, but wanted to report about the more expedited trajectory. And so for those reasons and that explanation, we hope that the committee will approve our request for oral conditional approval. Thank you.
Comments, questions, Representative Broda?
Thank you. You noted in your comments, in your testimony, that in 306F, where you define substantial as more than, where is that correction in the rules?
Do you have the packet in front of you? Because it's a
Yes.
very hot off the press, and we printed it off this morning. Yeah.
Apologies.
That's
Thank you.
okay. That's okay. It's been day to day trying to, and if you go to page 18, I believe. Sorry, 17? Yep. 17, it's F2, and we've struck substantial, and then we've added that.
Yes, thank you. I see it. Thank
Okay.
you so much.
You bet.
Senator?
So on your new rule F2, it says that affects 500 customers or more with an expected duration exceeding. No, never mind. I think I answered my own question. But I reread it again. You're good.
Thank you.
Sorry.
Well, I'm glad to know the careful work will straighten it out. I'm a little concerned that while you're very rapidly responding to some customers, the other customers and affected people don't get a chance to look at these new rules. And have you considered it, how it might affect them?
Well, I think, we went through the regular rulemaking process and doing our best to accommodate the utilities' last minute requests. That's as
Okay.
far as we've gotten, yeah.
All right. Representative Leon?
Thank you, Madam Chairman, and thank you very much. I live in a pretty populated area, so 500 customers seems reasonable to me. I just wanted to make sure that in other areas of the state that is also appropriate, because I know referring from my area to others doesn't always work.
Even in less populated areas, 500 customers is significant.
I would say 400. I would say 499 is pretty significant. I mean, this is one of those situations where technically we're saying 500, but if you've got 487, those people are going to be very unhappy, and even if it doesn't technically meet the standard. So how are we handling that?
Is there any restriction on reporting something that does not meet this definition?
Madam Chair, are you asking if they can also report if there's 400 if they want to?
Yeah, that's what I
It's
want to make
optional.
sure.
Yeah, yeah.
Okay, well, here you go. It also involves aircraft, trains, commercial boats, closure of a state highway. Considering how many of them we have, that covers a lot. Anticipated to be reported publicly. I think that we're covered for the 487.
Good.
Madam Chair,
Yes.
move to approve the amended conditional approval.
Thank you. Amended.
Seconded by Representative Leon. Any further discussion, comments? All right, seeing none. Those in favor?
Aye.
Opposed? All
Thank
right,
you.
Thank you very much. All right, DRA.
Before we move to the next item, we've had a request for public testimony from a representative from the PUC just to clarify the filing of their 200 rules.
Oh, please, yes,
Yes, good morning. I'm Sarah Fuller. I'm a senior advisor attorney to the Public Utilities Commission and their rulemaking representative. The Public Utilities Commission is going to submit their final proposal in December. So we had hoped maybe it would be November. It's not going to be November probably because our comment period, we've extended comment period through October 22nd. I understand that we would have to flip our 200 proposal a few days later to get it in November. The 180 days would put us on the December meeting. The agreement that the Public Utilities Commission has worked out with the Department of Energy is that if their proposal, which we have worked diligently with them and supported them to prepare and submit to fiscal impact on their waiver, if that is not ready to be approved until January, what we would do is we would submit for hopeful approval in December with an adoption date in January, which will allow them to continue to use PUC 201.05 as their waiver going forward because of RSA 12P14, which allows them to rely and use PUC rules unless they are amended. So because of the timing issues, I just wanted to put on the record very clearly that it isn't the intent of the Public Utilities Commission to have our procedural rules proposed in final format and be here in December to discuss those with you. And if the Department of Energy needs another month to go through the process to get their waiver rule, that's of course something that we would work with them as sister agencies to make sure that they're not left without rules. But how we would do that is we would just delay our effective date on our adopted rule. So I just wanted to clarify for the committee, and thank you for your time.
all right. Any questions? All right, thank you very much for clarifying that. We been wondering what's been happening to those rules. All right, back to the DRA.
So this is proposal 2024-138 on meals and rentals tax. And this actually should have been on consent. I had two comments that you can still see in your packet for the final proposal. Turns out it was just my ignorance in the field that caused these comments. My first is on 32. I was concerned because it was allowing operators to ask for cash for the taxes upon paying with a credit card. But this is not a requirement, it's a option, and it allows them to deal with the fees that come from doing a credit card action. And my other comment was about filing for a extension on a tax return. And I did not know that if you file on an extension, you have to pay the tax before you do that. I've never been late on my taxes, so I didn't know that was a thing. So those comments are no longer relevant, and so I have no other comments.
Are there any questions from the committee, concerns?
Motion to approve.
All right. It's been moved by Representative Hacken Phillips, seconded by Senator Lang. Questions, comments? Those in favor?
Aye.
Opposed? Okay, thank you very much. And other business. We have an expedited repeal.
Actually, that's an emergency rule
Emergency rule.
Oh, I'm sorry,
from
emergency rule.
HHS.
We have an
Um,
emergency rule, yes.
I'll discuss it briefly and then let the department fill in the details. This is a rule to require interstate criminal record checks for license exempt childcare providers. Currently, people in the home and the providers themselves have to have criminal record checks. This would require it for interstate under certain circumstances. It's required by federal law, and it is in the new state plan, which just was implemented at the beginning of this month. Is there a possibility that the department could have realized that they would need rules for this earlier? Yes, but the program did not realize that, and now they need the rules in place or they'll be in violation of the state plan and the federal regulations, which would subject the department to a 5% penalty, which could be more than $900,000.
Good morning. I'm Nicole Valenzola, Rules Coordinator for the Department of Health and Human Services.
And I'm Brian Clark, General Counsel for the Bureau of Child Development and Head Start Collaboration. So, yes, the Bureau of Child Development has been working on coming into compliance with the new federal rule. We had been working on the New Hampshire Connection Information System, which is the computer system, which will be a one-stop place to have background checks done, and it'll be able to cover in-state and out-of-state. And so the new requirement is to use that system because it's the only way we can do out-of-state background checks, and otherwise we just wouldn't be able to comply with the rule. And it's rather unfortunate that we did not realize that we were missing this component. We were focused on the New Hampshire Connections Information System. We weren't focused on the rule, and that was an oversight, and we didn't realize until September 18th, at which point we took swift action to do an emergency rule.
Any questions or comments? Okay, so if I understand this correctly, this is to do criminal background checks on licensed exempt providers?
That's correct.
Wondering what the benefit of being license exempt is, if they still have to go through all the background checks and so forth, other than the fee, of course.
state law currently requires the background checks. This will be expanded to out of state as well.
So if an individual has lived in a state other than New Hampshire within the previous 5 years, this is now the capacity to check that criminal background record check.
Oh, thank you very much.
Yeah, sure, of course.
Okay, Representative Leon.
Thank you, Madam Chair. As I was looking through, it seemed like there were a lot of changes within this emergency rule. Are all of those changes necessary in order to meet that federal deadline, or was there anything else added in alongside it?
Yeah, aside from editorial, like gender pronoun, things like that, everything else is correcting the website. It was an expired, outdated website. A lot of text you saw extracted was the very detailed former process that was paper and didn't allow for interstate background record checks. So yes, it does look like a lot of text, but it is connected to this right now.
Okay, thank you.
Anyone else? All right, thank you. We don't have to do anything to the emergency rule, so that's that. All right.
Thank you.
Is there anything else from anyone? Or Director Morrow?
3 quick things. First, I'd like to thank the committee members for the good turnout. Earlier this week, we only had 3 members committed, so we were a little concerned. I'd like to remind the committee that next month we'll be taking up the ED 306 school approval rules. One you heard last month, but postponed to November, and the other provisions will also be up in November. Also, for those of you that were not here last month, this is Douglas Osterhout. Some of you may know him anyways from the work he's done for OPLC. He is now the new me because I'm retiring after next month's meeting. And I will be leaving it in very good hands.
All right, thank you.
And we can probably cancel the continued meeting.
All right, let's do that. That would, and so we will meet again in November, and our terms do expire in the beginning of December when the session ends. So we will need to speak to the Speaker of the House and the Senate President, whoever that may be, to appoint a JLCAR very quickly so that we can have the December meeting.
Yes, and I've spoken with the chiefs of staff in both the House and Senate to remind them of that fact.
Okay, yes. All right, and thank you very much, and have a good weekend.